Hello everyone, and thank you for joining us today in a sponsored content webinar series. Our guest today is Carrie Palmetier of Palmetier Law. Carrie is presenting the second part of her two-part webinar series on SBIRs and STTRs. Both sessions are complimentary and recorded, so you can find the recordings on our YouTube channel. As we go through the presentation, feel free to type questions in the question part of the chat. Carrie will go through them and answer them at the end. Please allow me to introduce Carrie Palmetier. Carrie, it's so great to have you with us today. I'm going to put myself on mute and turn the floor over to you. Please let me know when you're ready for your next slide.
Next slide. So for those of you who didn't hear the first session, here's my who I am slide. Basically, I'm a former Air Force JAG who did most of her time doing government contracts in the Air Force, including at different contracting bases. And then I went to work for United Launch Alliance, which is a large defense contractor jointly owned by Boeing and Lockheed. And I've been on my own now helping small businesses. I only represent small businesses and I help them in all areas of government contracting. Next slide. Okay, so today we're gonna, last week we talked about SBIR, STTR program in general and some of the basic rules. Today we're gonna focus specifically on the IP rights, intellectual property rights, that come out of SBIR program, because the SBIR program is a high-tech R&D research and development program, and therefore there's always going to be some sort of intellectual property that needs to be protected. It's also one of the biggest benefits of the SBIR program. Next slide. Okay, so SBIR rights. This is what applies when data is first produced in the performance of an SBIR contract. These rights will apply for the small business prime, because the prime, as you learned from last week, has to be a small business, and then all small business or research institutions subcontractors. Not your large business subcontractors, but your small business or research institutions subcontractors. The applicable data rights clause, and we'll talk about what those are, but for the FAR and the DFARS, must be included in all SBIR contracts. If the contract is being done under a grant or cooperative agreement, there are similar equivalent clauses in the grant and cooperative agreement rules. However, you have to retain documentation. The small business has to retain documentation to support which technology, which IP was developed under which contract, so that you can support which level of rights are going to attach. So make sure you keep track of your statement of work, the technology that's developed, and which contract it's being done under. Under the SBIR program. So if you haven't taken the webinar on FAR Part 27, which is your intellectual property webinar, you may want to go take that class also, just because they are related. But generally speaking, under the FAR and the DFARS, there are subtly different language, but essentially it boils down to that the government receives the equivalent of limited rights or restricted rights under the SBIR program for a period of 20 years. And after 20 years, then the rights will convert to government purpose rights. And what that means is that limited restricted rights is the same level of rights that the government gets if the business developed the intellectual property at its own expense. So in this case, the government is funding the research and development and getting a significantly lower level of rights for a 20-year period. And then at the 20 years, it converts to government purpose rights. Government purpose rights means that they can use that tech IP for any governmental purpose. And I do mean any governmental purpose. So across different agencies, competition with others on a government contract. Versus the limited and restricted rights essentially boils down to you are the only entity, or the entity who owns these SBIR rights is the only entity who can use them. And the government has to buy them from that entity. So if it's you, great. You have a 20-year period in which the government has to buy that intellectual property from you that the government funded. And therein lies one of the biggest benefits of the SBIR program and why I'm a fan of the SBIR program. Unfortunately, the clauses, the regulatory process to make changes is very slow. So the rule for 20 years was in effect in May of 2019, and we expect that it will finally be changed into the FAR and the DFARS this year. We're watching for when it will be finally released. We've seen the iterations to get it there, but until that point in time, most agencies have issued a deviation to the FAR or the DFARS clause that says it's the 20-year protection period. DoD has done it for the DFARS clause as a whole. The FAR clause, different agencies have done it, not everybody. So just watch for those deviations and make sure you get the deviation version that has 20 years. Next slide. Oh, and Emma, I don't think you said it, but if you did. If you want chats, please, please, please feel free to ask chats. Emma will keep an eye on it, and we can do the Q&A to make sure that there's any questions. And if there's questions that aren't answered before the end, then I will follow up with you, or you can follow up with me directly. SBIR matters. Okay, so here's the biggest benefit. Government has funded your development of the technology in phase 1 and phase 2. Now, they can, not required to, but they may award follow-on contracts to you without competition. So in other words, they could come out and say, hey, company, small business X has this great technology that we need. They don't have to do anything but just issue you contracts. And there is a statutory exemption that's lies in that as long as they are buying the SBIR technology, they can't go buy something else from you. They have to buy the SBIR technology from you, and they can do so without competition. It also applies if what you end up developing becomes a component on a larger program and you're selling through another prime contractor. That prime contractor can also award to you on a sole source basis. And you can also sell the government this technology the government's funded for commercial purposes. So it's a pretty broad base, but that sole source capability is one of that ties in with the SBIR rights, is one of the biggest benefits. And the key for companies, and we'll talk about this at the end, is how to market that. Because if you just wait passively for somebody to come contract with you, you will probably never get a contract. You have to take the assertion to go find out how to market that technology and leverage that sole source capability. You also just need a compliance thing, update that database. Once you get an SBIR contract, you will get access to the database, and you just need to keep it updated. So some strategic tips for phase 3. So now phase 3, if you remember from the first presentation, is the commercialization. So we're not using SBIR funds. We are buying whatever the product is. There can be further evolutions of it, but we're into the program of record, the standard process, selling your IP that you developed in the SBIR program. It's okay as soon as you know or see that the government's gone out for a request for information or has said, hey, industry, what do you have? Raise your hand and say, hey, contracting officer, we have the solution for you. Not only that, it was an SBIR contract, so you can obtain it from us on a sole source basis and skip all of this other activities that you have to do for competition. Make it a whole lot easier on you. That you can do. You can talk to the contracting officer, you can talk to the program office, market your materials. Make sure that they know that you have an SBIR technology. Also, when you get a phase 3, you need to request that the SBIR clause be added so that it's acknowledged as a phase 3. It used to be really important because we had a rolling protection period where you had to have subsequent contracts to keep that SBIR rights protected. But with the change to 20 years, that urgency is gone. But what that clause does is if they agree that this is a phase 3 and the clause is added, any new IP you create that's a follow-on improvement to your SBIR phase 1 and phase 2 retains SBIR rights instead of the government getting a higher level of rights where they can do more with it. So it's a good strategy, but you need to learn how to market that very well. Next slide. Okay, so this, apologies, when we post the slides, we'll get it cleaned up. This was kind of a cut and paste. Okay, so I'm going to go down to the bottom. As I noted before, the first few bullets are all already addressed. The last bullet, the protection period for the 20 years, Again, it converts to government purpose rights. Energy has it going to unlimited. Clauses are, but if you have an older SBIR contract, one that was awarded definitely before 2019 or before an agency put a deviation in place and uses a deviation version, the intent is that if you get a follow-on contract and you're going to continue to use that older technology with the old periods, that's going to continue. But we have a gap because the SBIR clause only covers new contracts. It doesn't cover older contracts. So we're still trying to work with the government as a whole of how to extend those rights. But the intention is that because we back it up, if you have an older contract, it used to be that you would have a 4 or 5 year period, depending upon whether you were civilian agency or DOD, that was continually extended. Each time you got a new SBIR contract, phase 1, 2, or 3, it kept extending, and it would extend perpetually, never ended. That was hard to manage, unbelievably hard. And if you had a 1 year gap or a 1 month gap between contracts where the protection period expired, it was gone. So the government would then get unlimited rights. Now it's a 20 year period and the government gets government purpose rights. With most technology, 20 years is a sufficient period. It's also the same period of time for patent protections. But these older contracts, if you have one, the intent is basically that you're going to continue that same pattern, but they don't really talk about how to go about documenting that. So it's just something to be aware of. Next slide. Okay, so now we go into your process. What happens during an SBIR proposal process? We have phase 1 and phase 2, and then we have phase 3. Okay, so in the proposal process, just like you would with any government proposal, if you don't have to worry about the IP you're going to create in the performance of the SBIR contract, because the contract already says that all IP created or reduced, and developed in the performance of the SBIR contract will be subject to SBIR rights. But you could be bringing to the table other background intellectual property that you developed at your own expense. And you need to still assert rights to that you're going to deliver it with less than unlimited rights. Also, as you move forward and into phase 3's commercialization, you need to protect your SBIR data by making sure that any future proposals that include it, you've asserted your SBIR data rights to it. And if you haven't taken the FAR Part 27 webinar, I recommend strongly that you go take that class. Make sure you also include your subcontractors. So if your subcontractors are going to be delivering intellectual property, you need to ask them too. And so there's a standard table in the DFARS that the FAR has adopted that basically says you have to say what the IP is that's being delivered, what level of rights the government gets to it, and what is the rationale for it. You need to make sure that on any proposal, whether it's an SBIR proposal for your, or in the future, another proposal to which you're delivering your SBIR technology, that you follow this process. If you do not, and you deliver background intellectual property, background IP is IP created outside of that scope of the contract, and you don't follow this process, the government will get unlimited rights to it. So if you don't know this process, this is a key part, and it's one of the main points in time in a proposal where you have to think about your IP strategy in your future. Again, with your subsequent SBIR contracts, include that SBIR clause, engaging with the contracting officer early, and you can see throughout here, the SBIR clause needs to be added. It's very hard. It's uncomfortable sometimes to push to protect yourself when you're dealing with the government or a big prime, and that's a choice you can make. But if you don't push and protect yourself, you could be giving up your intellectual property. So I recommend you can politely, persistently push, and I recommend that small businesses do that. One other point, this goes both ways. If you are the prime contractor, you may not take title to your subcontractor's technical data or computer software created in the performance of the contract. You can ask, but you can't force them to do so. And similarly, In the future, if you are negotiating with a large business and they have a clause in their contract that says, hey, any new intellectual property you create in the performance of this contract, we're going to own. But if it's a government subcontract, the answer is no. They can't force you. But what this does mean is that you have to think very creatively about your strategy, because you can't own what your subcontractors create. So do you really want a subcontractor to create it? Because now you are bound to that subcontractor to be able to produce that end product using their IP for the future. You either have to have a license from them, you're going to have to purchase the IP from them, or you're going to have a long-term relationship with them as your subcontractor going forward. So just something to think about. Next slide. So we've talked about technical data and computer software. Those are data rights. There's a process that goes with those. Now we're going to move over and talk about inventions and patents. And these are completely different. Yes, the underlying technology is still technical data and computer software. It's still the same thing, but the protection process differs significantly. When you have an invention or a patent, we have the statute. It's called the Bayh-Dole Act. It's implemented through all of the regulations listed in there. It applies to the SBIR program, the same as if you had any other R&D contract. And so again, if you took the FAR Part 27 webinar, which I didn't teach actually, so somebody else, but go take that, is the same for any R&D contract. You will also see the basic language in all grants and cooperative agreements, even in other transaction agreements. You will still see this basic same language, full text versions. Basically, it applies to any invention conceived of or first reduced to practice in the performance of the contract. So if we are in that world, this statute and this process that we're going to go through in the next couple slides will apply. Some of the key parts: you have to ensure that your employees and independent contractors are assigning ownership to you. Even if you are paying for an employee to do work or an independent contractor to do work, companies do not automatically own what their employees create by virtue of the employment relationship. There has to be a document by which that intellectual property is assigned to the employer. It usually is part of the employment agreement. But if you're the small business owner and you do not have that assignment, you need to go get it. You need to do it right, correctly. So talk with a labor law, talk with a lawyer, HR person, or somebody. You also have to comply with the standard patent laws. Forget the government contract. There are laws for how you prosecute a patent, how you ensure that your idea can be patentable, such as making sure that you file for your patent before first use. You do not have public disclosure of the patent. Follow those rules because they will still apply even though this is a government contract. And again, this one, so beforehand when I said the primes can't take title, there's an interpretation issue. In this one, for it comes to inventions, it is an absolute prohibition. They are in violation of their prime contracts and the statutes if they try to take title from you, even asking to take title from you. They cannot take title. Next slide. Disclosures and reports. Okay, so to protect your patent, if you have an invention that is patentable, you must follow this process. If you do not follow this process, the government can take ownership of your invention and patent and leave you without any license. So follow this process. Your inventor has to disclose the invention to you, and you must then disclose it within 2 months to the government. Or if your employee doesn't disclose it to you and you become aware somehow or otherwise, you have 6 months. But basically follow the 2-month rule. You must require your employees and independent contractors to notify you. So again, you need to have a written process. You need to have in your independent contractor agreement, you need to have this as a requirement in their contracts. And then you have to disclose to the government any of the other following activities. If you abandon the patent, when and how you are utilizing the patent, when you elect to take title to the patent, and all patent filings. If you comply with these rules, you retain ownership. The government gets a royalty-free license for government purposes to use the patent. But if you don't comply, the government can come in and take march-in rights, and you can lose all rights and ownership. I want to also highlight through here, it's probably in your FAR Part 27 briefing, but authorization and consent applies, meaning the government can actually infringe a patent and is only liable for lost royalties. So that would apply to even inventions under a government contract. And then when you get to the stage that you're commercializing and you have taken this patent and you can now, even if you go to manufacturing, so if you have a patent that's going to lead to manufacturing, Bayh-Dole Act requires that subsequent licensing be to a firm who will substantially manufacture in the United States unless there is no firm exists or there's no domestic manufacturing capable of it. And again, this is because it's taxpayer dollars that are paying for this R&D, and so the intent is that the taxpayer dollars are growing the SBIR program, growing your patents as a whole to grow the US economy. Next slide. Okay, so I already mentioned it once, but patent filing is subject to the standard patent laws. The government contracting process does not disrupt the standard patent laws. So you would follow the same process for filing a government patent as you would a commercial patent with no government funding, with a couple exceptions. One, you have to include a statement that the patent was developed under government funds. It is a standard disclosure statement. All patent attorneys know how to do it. It's in the FAR clause. You just must include it. You have to monitor that, again, make sure you're not using it. You don't sell it before you file the patent and you don't disclose it. Another exception is that in the patent process, if you file a provisional patent, you have 12 months to file your non-provisional patent. In the government contracting world, you have 10 months. I mentioned authorization and consent briefly. Here's a more detailed on it. These two clauses are going to be in every R&D contract, and basically in a lot of other contracts too, is that the government can infringe a patent. So if in performing this SBIR contract or performing a future contract that you have a patent to somewhere, or somebody else has a patent to, or somebody violates your patent, it goes all different directions. The patent holder is only entitled to lost royalties. And the government, you have to sue the government because if the contractor violates a patent, the government steps into the shoes of the contractor and indemnifies the contractor. So those of you who may or may not read every clause on the contract, these are two very important clauses because one, it allows for you as the government contractor to have some freedom in doing R&D in regards to other companies' patents. But as you as the patent holder, it goes to show that there is this consequence out there that government contractors and the government may infringe your patent and you can sue the government, but you're going to recover lost royalties only, not damages, is basically what you're not going to recover. Next slide. Okay, marking requirements. Mark. If you do not mark your deliverables in accordance with the contract, and especially the data rights clauses, the patent clauses, etc., the government will receive unlimited rights to everything that you deliver. And unlimited rights means they can post it on the internet, give it to anybody for any kind of purpose whatsoever. You also have to be consistent, because if you mark the data one way in one contract and then in a different way, so in other words, you say SBIR rights in this contract, but then in another contract, you say government purpose rights, the government will always get the highest level of rights. Once you give them a higher level of right, you can never come back down to the previous level of rights. There is a process for correcting something that was mislabeled, but it is not perfect. And it means that anything that was previously labeled, the government is not required to destroy it. And so you have it labeled in two different ways in the government system. If you are delivering data under an SBIR contract, almost everything is going to be delivered with SBIR rights. You're going to mark everything with SBIR rights. But if you include something in your SBIR contract that was developed at other background information or something else, or another set of IP that's related, that built upon, to which the government has unlimited rights, you have to follow the marking requirements. And in the SBIR clauses, for example, it gives you a paragraph that says SBIR paragraph, government purpose paragraph, limited rights paragraph. You must use that marking exactly, at least on the cover page. You can then say, see cover page, limited rights, or SBIR rights. Mark each page. Again, once you mark, if you put the full labels on the first page, you can say, see title page. But if you have a mix of IP on individual pages, you may have to portion mark so the government knows which level of rights it gets to each part of that report. That also then means you've got to manage how you draft your report so you don't have things too intertwined. If you are delivering software or something that's not just a written paper, you can get creative on your marking ideas. You can use click wraps. You can document with the acceptance when you transmit the deliverable. You can use Adobe Portfolio, where one of the attachments within the portfolio is a data rights assertion table equivalent. Also, you need to be aware that the government can question an assertion. So if you submit something and you say, this is SBIR rights, and they come back and say, no, it's not, this is word for word out of some publication, you're the one who's going to have to justify it, just like you would on any other kind of research project. Or if you assert that something is SBIR rights and the government says, no, 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 you didn't develop it under the SBIR contract, you developed this for us under a different contract to which we have unlimited rights. The burden will be on you to show which contract developed, under which contract you developed each technology. So timesheets, tracking of by version control of your IP, some way to trace which parts are developed under which contracts. That is essential, and I deal with assertions, questions on assertion all the time, because the government is very sensitive, especially once it has spent multi-millions of dollars on it, that they get the level of rights that they're entitled to. Next slide. And by the way, I will run over past the 30 minutes, but not by much. The webinars will be available. You can feel free to listen. Also, just feel free to stay on and hopefully enjoy. Subcontract IP considerations. Unless you are performing 100% of the work by yourself, you will have a subcontract issue. You need to consider your supply chain. And then if you're developing the R&D, but it's going to be a commercial product, you also need to start thinking about who is going to be manufacturing and who's going to be providing you components to build that hardware going forward. Consider your commercialization. Consider the government domestic requirements, such as the Buy America Act, the Trade Agreements Act, the other prohibitions within the Berry Amendment or other DOD restrictions, the IP right, the patent right that we talked about, where manufacturing has to be substantially in the United States, licensing of the IP from your subcontractors. So if your subcontractors are going to be doing some of the R&D, or if you're buying parts from them that they own the IP to, you're going to have a long-term license with them. At what point in time do you make that determination? And how much are you going to pay for it? With an STTR, which is the SBIR program with which you have a research institution as a primary partner, instead of having an IP license between the two of you or in clauses that deal with your IP, you have to sign an allocation of rights agreement. There is a template. I will say I'm not sure I've ever had a research institution sign any of the government templates without changes. It is modifiable. It is not a mandate that it's word for word, but it basically says what level of rights you will receive to their background IP, their foreground IP, the IP created in the performance of the contract. And I will tell you, most research institutions, like most large businesses and everybody else, will not guarantee that they will license the commercialization to you. They will agree that you have an option, but you're going to have to pay for that license in the future to commercialize. Next slide. Okay, so I mentioned before about the protection period changing and going from 4 to 5 years to 20 years. That was done in 2019. Now, this is another one where a little bit of the government takes a long time to issue regulations and finalize the changes. But I will say it's going to be worth the wait if it comes out like it looked like it did in the proposed rules, because they're not just fixing the 20-year protection period. They are actually proposing to put SBIR program into the FAR finally. The SBIR program and the special rules for the SBIR program, including the sole source capability, are not currently in the FAR. We have to rely upon the SBA policy directive, which most contracting officers don't know about. So this will be a huge improvement. They're going to attempt to standardize the FAR and the DFARS requirement, maybe even eliminate the DFARS clause altogether, so there is only one SBIR clause and we don't have these differences depending upon which agency is awarding the SBIR program. Right now, when I checked just a couple of days ago, the final rule is going to be issued no earlier than mid-July. So we'll see where it comes out, but I have high hopes for this change. Next slide. Okay, so this is the treat. TABA. This is one of those 4-letter words that you're going to want to actually use. It is a great resource. It is not available in all SBIR contracts, but if it is, really need to consider it. This was one of the government's solutions to help small businesses bridge that valley of death and get from the R&D phase to the commercialization phase. It is money from the government that is awarded to you on top of, in addition to your SBIR award. It is available for phase 1 and phase 2. Again, not all agencies will do it. For example, the Air Force does not have TABA funds. NASA does have TABA funds. So it depends upon your agency, and it sometimes can depend upon the specific solicitation. And the amount can vary. But generally speaking, what we're looking at is $6,500 for phase 1 and $50,000 for phase 2. You cannot use that money to fund your own work. You use that money to pay outside consultants to help you get to commercialization efforts. And it can include your commercialization plan. It can include cybersecurity compliance. It can include accounting compliance. It can include patent prosecution, contract support, legal support. It basically, anything that manufacturing, building up your manufacturing facilities, anything that it'll take for you to get to that commercialization. You can use this money to pay for that work. It is a great resource. If it is available, do not leave it on the table. Please apply for it. It is, you do have to get quotes from consultants. The agencies have ones that you can use. You can go get your own, but just don't leave that money on the table. It's only available for phase 1 and 2, and it is in addition to the contract value. Next slide. So in other words, on the in addition to the contract value means it doesn't take away from your SBIR award. It's not subtracted from the amount of what you need to perform the R&D work. Exit strategy. So many small businesses are in the R&D world, and their exit strategy is potentially to sell the intellectual property they develop, sell the business, sell something down the road, and that's a valid exit strategy. Your exit strategy can also be to commercialize. And somewhere down the road, you go public or have some other activities, but exit strategy matters, and protection of your intellectual property will directly impact your exit strategy, because not only would it depend upon whether somebody's willing to buy the technology, but also the amount of money they're willing to pay for it. So protecting your SBIR technology and the rights related to it, so following these processes, can add significant value to your company's sales price down the road. For phase 3, phase 1 and phase 2 has to be a small business owner. But for a phase 3, those rights, including the sole source capability, can transfer to a large business. Large businesses will buy the technology and the assets that were developed under an SBIR program because of that phase 3 capability. But you need to manage that portfolio. You need to protect it. You need to be tracking it. They've had companies where they don't really pay attention to what technology was developed where, and now all of a sudden they don't know what the protection periods are. They don't know what level of rights. They haven't figured out what if they've sold it with the proper markings, you need to follow this process. It will affect you in the future. And if you go to have an exit strategy involving SBIR technology, if you use outside counsel, and I do actually recommend you use lawyers for sales of property. It's not one of the areas I do, but I do recommend you, and I know people who do, but I recommend you do have counsel for this. Make sure they understand SBIR technology. And if they have zero awareness of even how to spell SBIR, you need to find a different lawyer, because if you don't manage the sale properly, you're not leveraging this investment and this program to its full value. And I think that takes me to a conclusion. Next slide. Here's my contact information. The slides will be made available soon afterward. I'm going to make a slight update on that one area that I had to cut and paste. And if you go to the back, there's backup slides. These are the same backup reference slides in my other presentation, where you have the links. Next slides, Emma. The links to the SBIR programs and in general, and then the links to each of the agencies that have SBIR programs to their SBIR websites. Emma, do we have any questions?
Yes.
Okay.
If you are delivering a software prototype during a phase 2 SBIR, would you have to assert in the data rights assertions table that the government would receive SBIR data rights over that prototype to ensure the IP protection of that development work during the 20-year period?
Good question. As long as that software prototype was developed in the performance of this specific SBIR, no. If you developed it under a different SBIR, you should still assert it, because it's going to have a different protection period.
Okay.
But the SBIR clause in the beginning of it says you do not need to assert rights to any IP developed in the performance of this SBIR.
Okay, next question. Can a large business subcontractor assert SBIR data rights? The FAR seems to say only a SB sub can, but the DFARS does not have this limit.
Yeah, so for phase 1 and phase 2, only a small business. For phase 3, any size business, but it has to be the owner of those SBIR technologies. So a small business can grow and become large, and in phase 3 be able to assert data SBIR rights, but only a small business has to be the prime for phase 1 and phase 2. And if you, I would recommend you take my class from last week on that too.
Okay. Just want to confirm that R&D does not necessarily have to be a product, but can be a service or insight on a topic. Do we have to commercialize, or is it just an option?
Okay, so you're correct. R&D does not have to be a product at all. In fact, most of my clients are software services type R&D, research. Commercialization is the intent. So phase 3 is supposed to be, how do you commercialize that R&D? Grants and cooperative agreements. So sometimes the National Science Foundation or HHS will have an SBIR program where it's less of the commercialization, but a commercialization plan is almost always required for phase 2. So if it's just a cool question to go look at and doesn't have a commercial purpose, it has a lower likelihood of even getting a phase 1 or phase 2. So, you know, how you can commercialize it is something you're going to need to think about. Now, commercialization can be selling commercially. It can be selling it as a government. It can be incorporating that technology into another few levels of research that could eventually lead to a commercial product, or software. I say product, but it can be software, service, or anything else. I mean, I've had clients who create software out of the R&D program, and what they do in the SBIR program is the studies of some algorithm or some method of building the software differently to, you know, especially artificial intelligence nowadays, data gathering, but then what they sell is a license to use that software or access to a library or database.
Okay, that looks like all the questions. If anybody has any other questions, please type them into the chat now. Okay. Thank you, Carrie, for all the great information today on SBIRs and STTRs for federal contractors. And thank you to all who joined live or listening on the YouTube recording. As mentioned, the recording will be posted after the webinar is ending, and the slides will be uploaded to SlideShare as well. Okay. Thank you to everyone who's on here.
Thank you, Emma.
Bye-bye.